right, good evening, everybody. You just came to a hush all on your own. This is miraculous. Must be a good omen for tonight's event. We're going to get started. We have a lot on the agenda tonight. We know how busy everyone is. We also know that Game 2 of the American League Division Series is starting shortly. So we're going to try to stay ruthlessly on schedule, try to finish by 9 o'clock and get everyone home for the final innings of the Yankee game. My name is Nick Borton, and I am the proud chair of the Board of Directors of the Office of the Appellate Defender, and it is my pleasure to welcome you tonight to our 31st annual First Monday in October. I have been on the board of OAD for more than 11 years, and I've been the chair for about the last 5. OAD, as many of you know or will soon hear, is a crown jewel in the nonprofit world. It provides the highest caliber legal representation and holistic support to its clients, and it does so on a shoestring budget. But First Monday, this event tonight, is the only way that can happen. It is critical to our budget and our mission and to making sure that OAD has the means to achieve that mission. We also think this is the most fun and entertaining fundraising event in the city. And tonight, I'm confident, will be no exception. We have a fantastic lineup. Our advocates and the recipients of the Gould Award for Outstanding Advocacy, Helen of Lankler, Sifford and Wall, and David Patton of Hecker Fink. They are the most nervous people in the room, I can promise you that. Our Chief Justice and recipient of the Counsel for Justice Award, Ellen Patterson of Wells Fargo, and our mock Supreme Court Justices, Kate Cassidy, Maria Cruz Melendez, Ted Diskant, Christian Everdale, Julia Gatto, Justine Harris, Kristen Mace, and Jessica Masella. We are also proud to be presenting tonight the Beacon of Hope Award to Desheen Evans and the OAD Gideon Award to Cravath. More about all of those in a minute. I want to thank all of you for participating in First Monday. This event would not be what it is if not for the willingness of so many people with so many other commitments in their lives to dedicate their time and talent tonight to our cause. We ask a lot of all of you, especially Helen and David, and we are so appreciative of your commitment of time, talent, and energy. We also have a number of past First Monday honorees and justices with us tonight. Welcome back. And we are honored to have several members of the actual judiciary with us tonight too. Thank you all so much for being here. I also want to give a very special thanks to our corporate sponsor, FTI Consulting. Many of you know FTI as one of the preeminent global consulting firms, and many of you have worked with them before. They have been a stalwart supporter of OAD and First Monday for years, and we're so grateful for their incredible generosity supporting tonight. I want to thank all of you too who have purchased tickets and sponsored. We have raised an amazing $541,000 so far, which will directly support OAD's client-centered representation and holistic services. Now, you notice I said so far because, of course, the fundraising doesn't end with the calling of tonight's case. We're hoping to raise more money while we're all sitting here tonight because OAD truly does need the support to do their vital work. More on this to come, but I'll just direct your attention to the QR code on the pledge card in your journal. You're all used to multitasking, so there's no reason why you can't listen to the argument tonight and manage to send a little support our way. You can scan that code or fill out the card at any point tonight to make a donation. So without further ado, it's my pleasure to introduce OAD's amazing president and attorney in charge, Caprice Jennerson, who can tell you more about exactly what you are supporting tonight, the incredible work that OAD does every day. Thank you.
Good evening, everyone. So first, let me echo some of what Nick said, thank you to all of you for your support of OAD and your support of First Monday. An event like this simply does not happen without so many hands and so many generous supporters. So I want to make sure that I thank each and every one of you. We are delighted to celebrate each of our honorees and look forward to tonight's oral argument. Year after year, this event is such a success because of our dedicated board of directors, and especially this year's host committee, the board chair, Nick Bortin, Joanna Hendon, James Lunam, Tatiana Martins, and Jeff Udell. Thank you to all of you for the many meetings and calls and emails that we have shared over the past several months. Again, a thank you to our event sponsor, FTI Consulting, and Appellate Innovations, who year after year puts together our really beautiful journals. For 36 years, OAD has stood as a bright light for those entangled in the criminal legal system, but without the financial resources to engage legal counsel. Our mission is to provide outstanding appellate representation and post-conviction relief for people with felony convictions in Manhattan and the Bronx. We also strive to improve the quality of indigent defense, representation through education and training, and lastly, we advocate for a systemic reform of New York City's criminal justice system. Each day, we encounter individuals who have endured systemic inequities, often throughout their entire lives. Many of our clients are experiencing poverty and homelessness. Some have been diagnosed with or undiagnosed mental illnesses, which they grapple with day in and day out. Some of our clients endure food insecurity and inadequate education. And still, by the time they come in contact with OAD, the team of lawyers and paralegals and client service coordinators and other administrative personnel see people first. We see human beings who are so much more than their legal issues and their convictions. So I want to take a moment to acknowledge the staff of OAD. Many of them are in the crowd. I'd ask all the staff of OAD to stand and be acknowledged. And can we have a round of applause for those on the front line? OAD achieves significant outcomes that impact not just the individual client, but the broader community. Our work ensures fairness in the criminal legal system and serves as a check on abuses of power. Because of the work done by OAD, community safety is directly impacted and improved. Our team is instrumental in causing faulty indictments to be dismissed, new trials to be granted, draconian excessive sentences to be reduced, wrongful convictions to be challenged, involuntary pleas to be vacated, and negative immigration consequences to be avoided. We also work with our clients to address the burden of collateral consequences of incarceration. Our client services team provides supportive counseling and many referrals to help our clients with public benefits, housing, education, and other support around the basic necessities of life. And here we are, nearing the end of 2024, 61 years after Gideon versus Wainwright was decided. We are still calling out to be understood that public defenders are necessary and important in the conversation on criminal justice reform. Our practices, as Nick mentioned, are not fully funded, even though we are constitutionally mandated. We are often excluded from the conversation on community service, but we recognize that our clients who are closest to the problems also are closest to the solutions. And so we continue to amplify the stories of our clients in spaces where they may not be seen and where their voices have been silenced. So I thank you for your generous support that helps OAD continue the fight for justice for our clients and the broader community. So I have the distinct privilege of presenting the first two awards of the evening. The first award is the Gideon Award. Since 2018, OAD has awarded the Gideon Award to a law firm that has demonstrated a commitment to indigent appellate defense through its participation in the Volunteer Appellate Defender Program, as we call VAD. Attorneys at participating law firms get valuable hands-on experience on all aspects of criminal appeals, from issue selection to oral argument, all under the direct supervision of a supervising OAD attorney. Most importantly, OAD clients receive the support of dedicated associates and partners through the VAD program. This year's Gideon Award is presented to Cravath, Swaine, and Moore. Cravath has been a participating firm in the VAD program for many years. They have partnered with us on dozens of cases and are currently working on 7 matters as we speak. Earlier this year, Cravath represented a client in an appeal challenging the consolidation of 2 indictments relating to separate transactions where the court failed to give a limiting instruction. The client was found guilty in both cases where the quantum of evidence was significantly greater in one case than the other. In reversing the conviction, the court held that the undue prejudice caused by the cumulative evidence and failure to give a limiting instruction was not harmless error. The case was remanded to the trial court for new trial as to each indictment. Cravath has been a supporter of First Monday every year since its inception 31 years ago, and we are proud to have Cravath partner Lauren Moskowitz as a longtime member of the board of directors. We are so grateful for the long-standing partnership with Cravath, and it is my pleasure to present the Gideon Award to partner Ben Gruenstein, who will accept on behalf of the firm. Who's out of your way?
Thank you very much. I have to say, I thought the craziest thing that I'd seen today was Donald Trump campaigning earlier today wearing a yarmulke. But then I saw David Patton preparing for his representation of the government wearing an American flag tie, and that may be even odder. So thank you, Caprice, for the very nice introduction. The shoe is very much on the other foot. It is we at Cravath who are so appreciative of OAD, of the work that you do, of the opportunities that you present to us and to our young lawyers to handle important cases, to stand up in court. We so appreciate the support, the supervision, the strategic advice that your staff attorneys, supervising attorneys give to us. It is truly invaluable. As you mentioned, the Davis case, we are very proud of the result in that case, and we are proud of all of the work that we do with you and your organization, and I look forward to a continued relationship with OAD, and that hopefully we will have continued success. So thank you very much.
I think the next award is probably my favorite award of the night. It is the Beacon of Hope Award. This award is given to a former client who stands as a powerful example of the human capacity for resilience and highlights the importance of centering the administration of criminal justice around the inherent potential of every person. Our Beacon of Hope awardee, Desheen Evans, is a survivor of trafficking. She was convicted of acts that she was forced to commit by men who preyed on young and vulnerable girls. But Ms. Evans was actually a survivor long before the events that led to her conviction. Having a challenging childhood, she learned survival skills and many hard lessons that many of us probably never had to learn at such a young age. She navigated the foster care system, and by the time she was 18 years old, she was self-sufficient and independent. When she was arrested for conspiring with 2 traffickers, she proclaimed vehemently that she was a victim and that she was actually being abused. But she, unfortunately, was not believed. She was not seen as the typical person who would be considered a victim. She decided it was into her best interest to enter a guilty plea, and this was and still is her first and only conviction. Even at her sentencing, she continued to say that she was actually a victim. OAD was assigned to represent Ms. Evans and quickly went to work because we believed her. Her staff attorney at the time, Stephen Struther, began speaking with the district attorney's office about her case, and in painstaking detail, she recounted what had happened to her over many years, and she was brave enough to be able to do that. As wonderful as all of that is, Ms. Evans' story really doesn't end there. She has been gainfully employed since her conviction was vacated and sealed in 2021. She works in various capacities to help others. For example, she was a client aide in a homeless shelter, and then an eligibility specialist for the city's Human Resources Administration. She has earned her bachelor's degree in criminal justice and a master's degree in psychology. Ms. Evans is a fierce advocate for other people in need, and she remains absolutely one of the strongest, most resilient people OAD has ever seen. We are elated that she remains connected to the OAD community through her attorney, Stephen Struther. Please help me in celebrating Desheen Evans.
Hello, everybody. My name is Desheen Evans, and I want to tell you a little bit about myself, about my story and achievements, as well as my accomplishments. In 2016, I was arrested and wrongfully charged with conspiracy in the 4th degree. I was then convicted and sentenced to 2 years and 8 months in 2017. My back was against the wall, and I was scared. I felt like I had no one to turn to. During this time, I had a lot of time to think and pray and kept asking God, why me? I couldn't understand how did I get myself into this situation. A person who has never had a record and has had a college education, how could I allow myself to get to this point? Well, the story goes like this. I had met a guy that I thought had my best interests at heart, and boy, was I wrong. What I didn't know was the person would destroy my life at the time. I started doing things I would not normally do, and this wasn't me at all. What has happened to me, as I was hanging around this guy, I was being forced to indulge in bad and dangerous habits. If I didn't, I would be physically abused. Since that time, I have obtained my bachelor's degree and recently got my master's degree. I have been working for the city, helping families in need. And I am also trying to put my life back together in order to utilize my degree to obtain a decent paying career. I am so proud of my accomplishments and achievements today, and I want to thank my wonderful lawyer, Mr. Struther, who believed in me, and his organization. And that's all I have to say.
I told you that was the best award of the night. So it's about time to hear oral argument. In the case of Kousisis versus United States, the petitioner being represented by Helen and the government by David Patton. You are invited to read more of the details about the case in your journal, the Spectator's Primer. The issue presented is whether a scheme to induce a transaction in property through deception, but which contemplates no harm to any property interest, constitutes a scheme to defraud under the federal wire and mail fraud statute. So of course, this is not normally an issue that OAD deals with, so I had to do a little research myself, like what is this really about? And I'm sure many of you that do white collar work, you know what this is all about, but I had to read about it. And I found a really good summary on a Reed Smith blog. So I'll tell you what it said. I'll just tell you. I'm giving credit to Reed Smith because these are not my words, so Reed Smith, thank you. So generally, mail and wire fraud statutes criminalize schemes to deprive others of property. So what counts as deprivation and what kinds of property fall within the statutes is what we're going to be hearing about today. Here's sort of a hypothetical based loosely on the facts of the case. A party submits a bid in an effort to win a contract from a local governmental entity. As part of the bid, the party promises to employ a certain number of veterans to do the job. In part because of that promise, the party wins the contract. The party ultimately does a wonderful job and the government is pleased with the work. But it turns out that the party did not employ the number of veterans that it said it would. The party is prosecuted for fraudulently inducing the government to enter this contract. So the theory is, had the party provided accurate information, the government would not have awarded the contract to the party. And the theory continues that the government was deprived of property, thereby supporting a mail or wire fraud prosecution. So the debate is over whether this is deprivation or whether the not using veterans is actually a valid property interest. Somehow, David Patton and Helen are gonna make that all plain for you in just a few moments. So just some basic logistics as we move forward. The rest of the program moves forward without intermission. After the oral argument, OAD's board chair, Nick Borton, and the former board chair, Sean Hecker, will present the Gould Awards for Outstanding Oral Advocacy to the advocates and the Counsel for Justice Award to the Chief Justice. Then we will observe the observations of the mock Supreme Court, and at that time, the program will conclude at or about 9 o'clock. So if you have not done so already, please take a moment to silence or turn off your cell phones. And please join me in the courtroom of the mock Supreme Court of the United States as I invite our esteemed court crier, Myrna Felder, our only court crier, to open the court session. This is first Monday in October, 2024.
Please rise. The Justices of the mock Supreme Court of the United States. Now. Oyez, oyez, oyez. All persons having business before the mock Supreme Court of the United States are admonished to draw near and give their attention, for the court is now sitting. God bless the United States and this honorable court. Please be seated.
Thank you. The court will hear argument in number 23909, Kousisis versus United States. Caprice, where are the lights? Right here, far end. Okay, great. So Ms. Gred, we're going to hear from you first, and the white light will go on when there are 2 minutes left. A red light will go on when time is up, so my esteemed justices can see that, and you all, my justices here, should feel free to just jump in. I'm not going to try to direct traffic. Over to you, Ms. Gred.
It's beginning to as they say, can you hear me now? The question is an easy one because this court's prior decisions, from McNally to last term's decision in Simonelli, make clear that the answer to the question presented is no. A scheme that involves deception without contemplation of property harm may well violate other federal statutes, such as 1001, the false statements to the government statute, or 371, a scheme to impair or impede government function. Or, of course, the scheme may violate any number of state laws, but unless the scheme contemplates harm to a property interest, which this court has consistently described as a deprivation of money or property, It does not constitute a scheme to defraud within the meaning of the federal wire fraud statute. As this court stated in Kelly, quote, "The wire fraud statute prohibits..."
May I jump in for a second? Counselor, you just said that property this court held is limited to money or property. That's the property interest that's protected by the wire fraud statute. Does that reduce to simply a dollars and cents inquiry? Is it just about money? Is it that you get paid a certain amount of money and get fair value for services in return, and that's it? There's nothing else that's protected by that?
Your Honor, what the statute contemplates, as this court has repeatedly held, is that it protects only money, or what has been well recognized at common law as a property right. And there must be a deprivation of that money or property. It's not enough for the transaction to simply involve the passage of money or property. There must be an actual deprivation. And again, that has been said in Simonelli. It has been said in myriad other cases since the time of McNally.
Counselor, in Carpenter, we held that property could be confidential business information. It's not just that property is economic, monetary property. Isn't that right?
With respect, that was economic property, Your Honor. That was valuable confidential business information, and the court found that it did constitute property because it was well settled, not significantly because the journal had contracted to call it property, but because, in fact, the common law had long recognized confidential business information as a property interest, as an economically valuable property interest. And it was for that reason that the court held it was within the ambit of the wire fraud statute.
Counselor, in this case, just following along with my colleagues, don't we have an actual economic loss? In other words, wasn't the 2.25% upcharge money or property or both that otherwise would have gone to PennDOT had it not we not had this fraud?
Absolutely not, Your Honor, and we know that for several reasons. Let's start with what happened at trial. The government at trial proceeded on the theory and argued to the jury that this was a deception that had nothing to do with dollars and cents. It had nothing to do with economic obligations. It had to do with a non-economic obligation. The government at trial at no time argued that PennDOT was in any respect out of pocket economically as a result of the deception that occurred in this case. The 2.25%, Your Honor, which, by the way, totaled $170,000, about 0.2% of the entire contract price, was brought up for the first time on appeal as it became apparent that the property theories being advanced by the government were in trouble.
Well, but what about the $70 million contract? I mean, wasn't the jury instructed that depriving an agency of fundamental basis of its bargain could constitute a property interest?
That was part of the instruction, and with respect, Your Honor, that instruction was error. Again, the court has held that there must be a deprivation of property, and to borrow the words
Counselor,
of, yes.
What's the petitioner's position on why the simple paying out of the contract amount would not constitute a harm?
If that were the case, Your Honor, then last term there would have been a very different decision in Simonelli, the Buffalo Billions case. That was a case about a $750 billion contract that was obtained as the result of what the government contended was a fraudulent scheme. The court still required that there be an analysis of what deprivation had there been. It wasn't enough that money changed hands. It wasn't enough that ultimately the motive for a deception may have been financial. I think in most cases involving deception, motive is financial. Kelly is a notable exception there. It was political retribution. But in the ordinary case, the motive is financial. And it wasn't enough that money changed hands in the course of the contract or getting the contract. There needed to be a deception that deprived the counterparty of a cognizable interest. Yes, Your Honor.
Simonelli involved the theory of right to control, right? And didn't we leave open the possibility that that case could be retried as a direct fraud? Isn't that what happened here effectively?
Your Honor, there was a lone concurrence by Justice Alito that suggested that it might be possible for the government to proceed on another theory. And notably, the government initially in Simonelli proceeded by a contract theory that the object of the deception was getting the contract. The government dropped that and wisely in the lower court and proceeded on what it thought was a safer theory, the Second Circuit's well-recognized right to control theory, that this court properly rejected, finding that it strayed too far from the recognized property interests that the wire fraud statute was enacted to protect.
But here, wouldn't you agree that the DBE participation was an essential element of this contract? It was written into the contract, wasn't it?
Your Honor, I think you can look at the Court of Appeals decisions and see how difficult a task it is to determine what is essential and what is not. Courts have struggled with what is the basis of the bargain, what is essential. What we know is it was a non-economic part of the contract. It was by definition.
It's a factual development issue, that if the government had done a better job developing the facts of how material or essential it was, that would have been sufficient?
Not at all, Your Honor, because again, going back to Carpenter, a case we discussed a bit earlier, in analyzing whether the confidential business information was property or not, the court noted that the journal in its employee manual, which all employees were required to agree to abide by, had designated it as property, essentially making clear it was material to the journal. And this court said in Carpenter, the only significance that has is evidentiary. It helps us determine if the interest that has been deprived is in fact property. That helps us determine that there was specific intent to defraud. It does not create property. Private parties cannot decide this is a property interest.
Just follow up on that. If here the state of Pennsylvania had decided that it was not urgent to paint the bridge or the Amtrak station, and they just wanted to do it in the next 10 years or so, but it was urgent and necessary to the state to be able to improve the involvement of minority and small businesses. And so it made a decision that it would not grant a contract at all unless there was an appropriate business who would advance that state goal. And if no one bid that met that standard, then they would have kept their money and painted the bridge somewhere down the road when there was a proper bidder. Wouldn't that demonstrate, if those facts had been developed at trial, that would demonstrate that this was an essential aspect?
No, Your Honor, and I think it's also important to focus on the nature of the interest here, because this court in Cleveland and this court in Kelly have focused on whether the interest at issue is a property interest or a governmental, a regulatory interest.
The cost of the painting in that situation would be the $700,000 that the state would be deprived of. It would not have spent that money if there had not been a proper bidder.
But you would still look at what the deception was targeting. And the deception was targeting interference with a government interest. The hypothetical that Your Honor is posing, I assume, includes the deception of the individual saying, yes, I will hire DVDs, I will use them.
Can I give you a hypothetical sort of to test what Justice Mace has raised? I own a zoo, and I'm in the market for a zebra. And I write out a contract. I'd like a zebra. You have a zebra. Just so happens that your zebra is all white. It has a genetic issue, and so it's all white. So you decide to paint the zebra. In the contract, however, there's a clause that describes what a zebra is, that it includes black and white stripes. I pay you money for the zebra. I discover after I've paid you money for the zebra that the stripes were simply painted on. Are you saying to me that the object of your scheme was not to obtain money from me for the zebra, rather the object of your scheme was to paint the stripes on the zebra?
I'm finding myself thinking of the Charlie the Horse case that's in our materials, Your Honor, where there was a decision that court itself struggled with, of saying, is this a fraud? The author of the opinion, State against Mills, and it's a case that has been cited by respondent. In fact, so far as I can tell, it's been cited only by respondent, for the proposition that if there is unique property or specific property and you're deprived of it, that constitutes a fraud. It is far from clear that represents the general rule at common law, but more significantly for present purposes, it has no relevance to a services contract case, because at common law, in contract law.
Isn't that case just about cheaters? I mean, isn't that what the wire fraud statute is designed to punish? People who cheat the system, and here someone cheated to get a very valuable contract. You lie, you get something of value. Seems like a crime, no?
Your Honor, not every dishonorable act, not every deception is property fraud. It can be governmental obstruction fraud, again, 371. It can be false statements, which was charged here. But unless it was fraud that was targeting a recognized property interest, it is not property. And just because I think my red light is going to come on soon, I would commend to the court's attention the Sixth Circuit in Sadler, a case in which the court noted that certain things bear no resemblance to the common understanding of deception. In that case, it was paying the going rate for a product. I would submit to the court, as my red light goes on, that one thing that bears absolutely no resemblance to the common understanding of deprivation is doing an excellent job painting bridges for $12 million less than the next lowest bidder was willing to do it for. Thank you.
Thank you, Counselor.
Thank you.
Thank you, Ms. Gred. We'll see you again for rebuttal. Mr. Patton, we'll hear from you.
Thank you, Madam Chief Justice. May it please the court. David Patton on behalf of the God-fearing people of the United States of America. When petitioner intentionally lied about a material aspect of a lucrative contract in order to induce the state of Pennsylvania to pay him $85 million, he committed fraud, plain and simple. Wherever some of the more challenging lines may be to draw when it comes to the contours of wire fraud, petitioner's conduct, this conduct, falls well on the criminal side. When a party to a transaction intentionally lies at the outset of the transaction about its intention to perform a core essential aspect of the deal, and it does so in order to obtain the other party's money.
I'm sorry, can I interrupt you?
Sure.
According to who is this an essential part of the deal?
So, respondent makes much of the length of the contract, but in fact, there were 2 pages of unique requirements that detailed 17 requirements. only one of those requirements stated in black and white, this is a material aspect of the contract, and that was the DBE participation.
So is it the government's position that every contractual term, if it is breached, then will subject the parties to a wire fraud indictment and arrest?
Not at all, Your Honor. The government's position is that it must be a material aspect of the contract. And if the court were so inclined, could in fact create a heightened materiality standard if it felt that materiality itself wasn't enough.
But Counselor, is materiality defined just by what's considered material under the terms of the contract? You can imagine, or you may have seen, contracts in which it states that all of the terms of the contract are considered material.
And it would not be guided entirely by what the contract says, but courts are no strangers to providing materiality instructions. There are numerous federal crimes that have a materiality element to them: perjury, false statements, securities fraud. There are others. We are used to instructing jurors that there is a fact-bound decision about materiality to be made, and courts are very comfortable, and juries have for centuries made decisions about materiality. It is not an insurmountable hurdle.
Sorry to interrupt. The core of this case, whether material or not, is that information that the government contends was necessary for Penn DOT to make a decision was withheld, right? How is that different from Simonelli? How is that not the same right to control theory repackaged?
It's very different, Your Honor. Simonelli was very confined to whether or not the right to control theory was in fact a valid theory. And as my apologies, someone on the court noted just a moment ago that in fact there may be a direct traditional property fraud claim to be made against Simonelli, and in fact last week the Second Circuit remanded the case to the Southern District precisely to retry the case on that element. By the time Simonelli reached this court at oral argument, the government had conceded that the right to control theory was not a valid theory. The only question before this court in that case was whether or not the court should return it with a judgment of acquittal. And the court declined to do that precisely because there may in fact be a traditional property fraud claim to be had.
And so what happened in Simonelli?
Case, is your claim actually property, or is it money? And if it's money, are you saying it's the value of the entire contract that was lost?
The property element could be satisfied in any number of ways in this case. There's the $85 million that the petitioner defrauded the state of Pennsylvania out of by lying to obtain this contract. There is the contract itself. There is the 2% markup on a regular basis.
It's contained within the overall bid. There's no incremental cost there.
An incremental cost is not an aspect of the wire fraud statute. If I may be permitted to give another hypothetical. Perhaps I am a great lover of freedom and liberty. And so, of course, one of the ways that I could most express my love of freedom and liberty is to purchase a gun. But I want to make sure that it's not just any gun, it is a gun made by the sweat and toil of Freemasons. That's a significant part of expressing my love of freedom and liberty, and I make that very explicit to the seller of the gun, and they promise me it was made by Freemasons, and instead it's made by the Chinese.
Isn't that a civil lawsuit?
It is hard to imagine a more damning.
But here, it's the government who wanted the DBA participation. The state of Pennsylvania perhaps didn't care. They're only doing it because the government required. What the state of Pennsylvania wanted was their bridge painted, which they got their bridge painted. So doesn't that change your great love for the Freemason gun analogy?
The contract was between petitioner and the state of Pennsylvania. The state of Pennsylvania's reasons for wanting certain features of the contract, for considering certain features of the contract essential, That's the state of Pennsylvania's business. That has nothing to do with whether or not it is in fact essential. If I may,
it's the jury's business, right? The jury has to find it's essential. You would agree with that, right?
has to find that it is material. Again, if this court wanted to set forth a slightly heightened standard of materiality, the government wouldn't oppose that.
I'm sure juries could follow those instructions. What I'm concerned about is how does the regular individual out there know in advance whether or not something's material enough to warrant criminal prosecution versus a civil breach of contract claim?
In the same way that we have dealt with perjury, false statements, securities fraud, which all contain materiality elements. I will say that there is, frankly, in petitioner's briefing, I have to say a fairly offensive insinuation that prosecutors cannot be trusted to exercise wise discretion in terms of making these charging decisions.
I'd like to ask you about another example of when the government used wise discretion, and that's when it conceded in Simonelli that it screwed up by being too cute by coming up with this right to control theory. So by the time it got to this court, it recognized that it shouldn't try to do that, shouldn't try to proceed under an intangible rights theory, and instead should go back to basic wire fraud and instruct the jury accordingly. Why did the government do it again and try to pursue this fraudulent inducement instead of just proving a fraud? Fraud is fraud. Prove it up under the regular jury instructions.
With respect, Justice Mace, that is what the government did in this case. This is a classic property fraud case. The theory was always that the state of Pennsylvania was lied to in order for the petitioner to take $85 million.
Counsel,
imagine,
according to the record, Alpha needed to certify over a number of times that they were in fact using a DBE. What role do those continued certifications play? Say, for example, we don't believe that at the start of the contract there was an intent to deprive. What role do the certifications play?
Well, thank you for that question, because I think it goes to yet another way in which property was obtained falsely in this case. There were ongoing certifications that the DBE percentages were being complied with, and as part of that, petitioner drummed up phony invoices that included within them more than a 2% markup on the cost in order to cover
Counselor,
the lies about the DBE
I don't think anyone's
percentage.
disputing that they obtained property here. I think the question is whether or not the state of Pennsylvania was deprived of any property, because it got something in exchange for the money it paid. It got exactly what it needed, which was painted bridges. I think to the extent there's something more, that's an intangible property right. And we have always focused on tangible property rights, and intangible property rights are the honest services provision. And that's limited to bribes and kickbacks.
Well, with respect, Your Honor, Carpenter does say that property can be intangible. That was the business information held by the Wall Street Journal. There was never an allegation in Carpenter that the Wall Street Journal lost any money. So there can, in fact, be intangible property rights. But more to the point.
I have a very basic question, which is, isn't this simply unfair? Isn't it simply unfair to the petitioners to hold them criminally liable for conduct that even we cannot agree about whether it's a crime or not?
Again, with respect, Your Honor, I think petitioner may be one of the few people confused about the meaning of fraud when he lied intentionally at the outset to obtain 85. Imagine if you will, there had been 3 bidders for this project, and they all came in at the exact same price. And petitioner became aware of this and went back to PennDOT and said, I know the bid calls for 7% DBE participation, but you know what? I'm going to sweeten the deal. I'm going to do 15% DBE. And PennDOT made its decision entirely based on that representation. Surely that is fraud. And surely this court should not so narrowly constrict the meaning of wire fraud to absent that sort of wrongful conduct.
With respect, Counselor, we are in the business of making the hypotheticals, not and tell us how the rule of lenity, one of the most important principles of construction in the area of criminal law, affects your analysis there.
Lenity is extremely important, Your Honor. I've often talked about the importance of the rule of lenity. But it simply has no place here. This is a clear-cut case of fraud. There is no ambiguity here. This was a lie, an intentional lie, a repeated lie.
Well, Counselor, I think you'd agree with us that simply lying by itself is not a crime. Our precedents have held exactly that on many occasions, not too distant past. I think what you're trying to offer us is a limiting principle of some kind, because you recognize that if it's just lying for lying's sake, that would be way too broad. So you've proposed materiality. And that may be workable, it may not be, but is the difference, at least on the facts of this case, that the PennDOT made it an explicit condition of the money being released or awarded that the contractor would use DBEs, and it was explicit, and that they knew that had they not abided by that condition, they wouldn't have otherwise gotten the money. And because it's that explicit, that we can charge wire fraud. Is that the limiting principle? Is that what makes this case different than some other case where it may be implicit?
Not only was it explicit, it was the sole requirement that had the language that said, this is really important to us.
But Counselor, then aren't we back to the question of whether it is the contracting parties who define what is material and thus what is criminal?
Certainly the contracting party's understanding is highly, highly relevant to the decision, but ultimately it is a jury's decision, and they will be instructed, as jurors have often been instructed, on the definition of materiality that's been used in numerous other federal statutes.
Would it matter if the defendant petitioner had given the money back?
No, Your Honor. The statute, again, does not depend on any sort of actual economic loss. It is the scheme to defraud. This is the language of the statute.
There's no economic harm required, but how, if you answer the question that way, how do you avoid the slippery slope problem that is pointed out by the petitioner, where you have a contracting party intending to possibly breach or not perform under the contract if certain conditions arise? And that is something that happens all the time. Parties go in recognizing that there could be a lack of performance, but they just don't either collect or pay, or they don't insist on performance from the other side. Then you just have a contract dispute. So you answered the question to say if they didn't give the money, if they did give the money back, it would still be fraud. But how is that different than just a breach of contract?
It is the intention at the outset. Like so many other offenses, it is the mens rea at the time that the conduct occurs.
What is the intent that's required under the statute?
The intent that is required is a knowing false statement in order to obtain property.
And a false statement would not include, I intend to perform this contract, even if someone says that knowing they may not.
If what they are making a false statement about is their intention to perform any material aspect of the contract, and they do that with the intention to fraudulently obtain money, then that is wire fraud.
Let's assume the government said that the particular name of the particular workers who work on the project is material to us. You have to hire people by the name of David to work on the project, and the contractor breached. Is that fraud?
Well, again, that would go to the materiality question.
And that's a jury question.
It is a jury question.
And when you say that there's a difference between materiality and essential element to the bargain, what's that difference? What's that heightened materiality standard you're talking about?
We have used that essentiality language, borrowing from this court's decision in United Services, in which this court described materiality as a demanding standard, as a real check on government overreach. and it talked about it in terms of an essential element of the contract. Now, in other places, the court has defined materiality differently, and certainly, again, the government understands that it is important to have this limiting principle, this check on overreach. We think materiality accomplishes that, but if there were some sort of heightened materiality standard, that would accomplish it as well.
Let's assume, just to keep going with that, your adversary makes a great deal about the regulatory interest. Let's assume this wasn't a government contract. Let's assume this was two private parties. Would the same analysis apply if this had been a private citizen who wanted to hire, and specifically focused on hiring, minority-owned businesses to paint their, I guess, personal bridge? Would the same analysis apply?
It would, and it's part of the problem with petitioners' reliance on Kelly and Cleveland, right? This is not an instance like in Cleveland where a person made false statements in order to obtain a gambling license, which was deemed not to be property. That was a regulatory interest. There, the state of Louisiana was not out any money. In Kelly, the petitioner schemed to change the traffic on the GW Bridge, but again, was not depriving New Jersey of any money other than in an ancillary way, was certainly not obtaining money. And here, part of the problem with petitioner's argument, this does apply in the marketplace. This is a classic marketplace situation, and you might have...
Counselor, isn't it fair to say, though, that if we use this materiality test that you've been discussing, that we're doing an end run around our line of cases that discuss the fact that we should be looking at long-established property interests? If materiality can be determined by the parties, what happens to the whole line of cases that we've determined where we really are looking at what's been well established in common law as a property right?
To be clear, money and contracts are well-established property interests. The materiality standard goes to the false statement. And I think part of the problem with the petitioner saying, oh, well, there might be other crimes that could apply here, 371 or 1001, is that those only apply as offenses against the government. They don't address...
So you're not arguing that the ability to contract is in itself a property right?
Contracts are certainly a traditional property right. I believe Justice Alito noted that in his concurrence in Simonelli. But leave aside a contract.
Every material breach of a contract is a violation of the wire fraud statute?
If it is done intentionally at the outset with the purpose to obtain money that would not be obtained absent the lies, yes.
But isn't there a principle that parties should be able to breach a contract if it's efficient?
Sure, after the fact, if the contract wasn't obtained by fraud, certainly. There are certainly overlap between fraud and breach of contract. Not every breach of contract is fraud, but some can be. Thank you, Your Honor.
Thank you. Thank you, Mr. Patton. Ms. Grad, we'll invite you back. You have 5 minutes for rebuttal.
Thank you, Your Honor. I think all of us in the defense bar were relieved that Mr. Patton's decision to join the government came so late in life. I think we're also even more relieved that it's likely to be short-lived. But even the most effective advocate cannot defend the indefensible, and that is what Respondents' Counsel has been doing here.
Ms. Grad, the government sets conditions for benefits all the time, right? Food stamps, you have to qualify for them. Medicaid, you have to qualify it. You apply for financial aid to a public university, you have to meet the criteria. Is it your position that if you lie about your eligibility for criteria for any of those, that that's not fraud, that that's a regulatory interest?
It is not property fraud, Your Honor. And again, you look to the guidance of Cleveland of is the interest that has been obtained by fraud that the interest holder is deprived of, is it property in the
Money is
hands
property, though.
of the victim? And Cleveland held it is not. And that's a very important point, Your Honor, in this case as well, because the fraud and the inducement theory is suggesting that you obtain a contract by fraud, an unexecuted contract, an unawarded contract by the government is not property in the hands of the victim. And Cleveland teaches that that is not sufficient to satisfy the wire fraud statute. It must be property in the hands of the victim.
So if this
Property was the payment by PennDOT, right? The cash money that went to the fraudsters.
That,
right? And there's no harm required under the statute. The government is not required to prove that there is an actual economic loss.
There was a passage of money, Your Honor, in exchange for services that were to the complete satisfaction of PennDOT as an economic matter.
And the deprivation, you've used that word, is the deprivation of that money.
No.
And the fact that there's no economic harm doesn't matter. Would you agree with me on that?
No, I would not, Your Honor. The deprivation that occurred, the interference that occurred was with the regulatory interest, with the interest of having...
No harm is required.
No, I do not, Your Honor.
And what do you cite for the proposition that you need to have an actual loss?
Okay. Actual loss is not the same as economic harm, and we saw that in Carpenter. It is most often expressed or manifested as an actual loss, but the two are not equivalent. And so that there can be economic harm that doesn't result in a realized loss, as was the case in the Wall Street Journal.
And there's no requirement of actual economic loss, and there's no requirement of an intent to cause any loss.
There is a requirement of an intent to cause economic harm, Your Honor.
But not loss.
An intent to cause economic harm. And in most cases, that will be manifest by an actual loss.
Ms. Grad, your Cleveland argument wouldn't hold if this was a private dispute, right? If your client had, lied about what was deemed a material condition in a private contract, that argument wouldn't hold?
I actually think it would hold, Your Honor, for a different reason. And I'll think of the 11th Circuit case of Tehaloff, which was a case in which an owner of a bar paid young women to pose as tourists to suggest to traveling businessmen that they come to the bar and have a drink. And the court found that fell outside the ambit of wire fraud, looking correctly at what the economic basis of the bargain was. The fact that there might have been non-economic considerations of the traveling businessmen in coming to the bar wasn't sufficient for them to say that there was, they did not receive the benefit of their bargain. So in the private context as well, private parties could have non-economic reasons for wanting to enter into a transaction, and just as government regulatory interests do not fall within the purview of the wire fraud statute, non-economic private interests do not as well. Very hot bench.
Thank you, Ms. Grad. The case is submitted.
Please rise. The mock Supreme Court of the United States now stands adjourned. The court will reconvene on Monday, October 6th, 2025 at 10 a.m.
Okay, so that lived up to the billing. Another round of applause for our fantastic advocates. Imagine being told, we want to give you an award because you're such a great lawyer. You just have to perform in front of every single person you know in the legal community. But they discharged their duty incredibly well. We're so grateful to them. And it is now my privilege to introduce the first winner of our Gould Award for Outstanding Oral Advocacy, whose outstanding ability we've all just had the pleasure of watching, and that is Helen Grad. So I'm not done yet. One thing I quickly learned in speaking to people around town is that Helen's legal acumen and reputation as a world-class litigator are matched only by her graciousness, her humility, and her reputation as a world-class person. Every single person I mentioned that to whom I mentioned that we were giving the Gould Award to Helen this year said the exact same thing. They said, "Oh, she's the best." And you can scour the legal community and not find one person who has anything less than the highest praise for Helen. It is quite remarkable. Early in her career, she served for more than 7 years as an assistant U.S. attorney in the Southern District of New York, including as chief appellate attorney and as first deputy chief of the criminal division. She went on to join Lenkler, Siffert, and Wohl, and for over 30 years has maintained an incredibly diverse practice representing individuals and companies across all manner of cases. It would take too long to list all of her accomplishments, but I think the ultimate sign of her esteem in the legal community is that she is the counsel of choice for other lawyers and law firms when they need their own counsel. At my own firm, on those rare occasions when Sullivan & Cromwell needs its own lawyer, rare-ish, our discussions always end the same way: call Helen. No last name ever even needs to be mentioned. But it's not just her smarts and her judgment that sets her apart. It's the level of commitment that she brings to all of her clients. Perhaps the Chamber's Legal Ranking Guide put it best in their review of Helen a few years ago. Chambers described Helen as, quote, willing to go to the ends of the earth for her clients. What else could you ask for in your counselor? Helen is also a true pillar of the legal community. In addition to being a trusted advisor and tireless advocate for her clients, she has taken an active role in numerous committees, boards, and professional associations. She serves on the Criminal Justice Act Advisory Committee for the Second Circuit. She chairs the Indigent Defense Organization Oversight Committee for the First Department Appellate Division, and she's been an active member of the City Bar, is a member of the New York Council of Defense Lawyers, and has served on the board of Judges and Lawyers Breast Cancer Alert, to name just a few. I was also fascinated in my research about Helen to learn that before she attended law school, she obtained a master's degree from Yale in Russian literature. And I think there's something to that. I think there probably is no better education anyone could receive in human psychology and concepts like guilt, redemption, and justice. Perhaps Helen's example should inspire law schools to rethink their curricula. In recognition of her exemplary career and contributions to the profession, it is my great pleasure to present the Milton S. Gould Award for Outstanding Oral Advocacy to Helen Grad.
Nick, thank you so much for those extraordinarily kind comments, and I am so glad this is done. As some of you may know, we picked sides in this argument, David and I, through a coin flip. We weren't in the same room, so David did the flip and reported the results to me. And And as a result, I'll never know for sure whether David actually won the role of government or whether he was just too kind to say that he had won the role of petitioner. Knowing David, the latter possibility is just as plausible as the former. But in any event, I am so honored, especially now that the argument is over, to be standing here in support of OAD. As everyone in this room knows, what we do is hard. It takes a toll on us, it takes a toll on our families, and in the case of my own family, that toll has been expressed in a long-running family joke that our daughter was born 2 months early because, 10 days early, sorry, because she spent 2 months in utero listening to a judge say, "Can't we move this along, please?" In the case of my son, it was expressed in him emerging from a conference room one day where he had been waiting too long, yet again, for his mom to get off the phone with his forehead stamped subject to protective order. I won't comment on who the culprit was, but his sister was spotted in the vicinity. And in the case of my husband, it's expressed in the question he's asked me more than a time or two in my years in practice and our marriage together of, do you think you could find more civil cases to work on? You're a lot more fun when you're doing those. And my husband, Bill, was right, because what we do is hard. And it's hard even if we're blessed, as I have been blessed, with the support of extraordinary partners, the sort of folk who I would call if I were ever in trouble. But as hard as the toll is on us, it's obviously so much harder on our clients. And that's true even if they have the means to mount a robust defense, and even more so when they do not. And that is why I am truly so pleased to be standing here in support of OAD. I first learned about OAD when I was appointed to a committee Nick mentioned, the First Department Indigent Defense Oversight Committee. I arrived at the committee for my first meeting to be greeted with, "Welcome, you must be the Fed." That was right. I had grown up in the federal system, which meant that my first experience with indigent defense was the absolutely amazing federal defenders. The folk who terrified me as a young prosecutor because they knew what they were doing, and I was convinced they knew I didn't know what I was doing. They were the people who held my respect throughout my time as a prosecutor because they kept the government honest. So I was so eager when I joined the Oversight Committee to learn about the stateside equivalent of federal defenders. And what I learned was that there is an amazing array of providers, both on the trial level and on the appellate level, and I came to admire them all. But I especially admired the model of OAD. And that was because OAD not only did a wonderful job of defending its own clients, it made, as part of its mission, expanding the pool of people who would be available to represent the indigent. They created and still have a program where the private sector can partner with OAD. A young attorney from a private sector firm can be assigned to a case, work under the supervision of amazingly experienced attorneys at OAD, and have the experience of representing somebody and learning how to be a defense attorney. The client gets the benefit of experience, wonderful defense, and the broader base of clients get the expanded pool of attorneys available to potentially represent the indigent. It is an extraordinary program. Our firm has participated in it numerous times. We look forward to doing so again. So if you had a good time tonight, if you enjoyed watching David impersonate a government attorney, I know I did. If you enjoyed analyzing whether I dealt with the questions from that extraordinarily hot bench well enough, I would ask you to please consider increasing your support to OAD. Everybody who's here is with a firm, in all likelihood, that has already contributed to OAD, but you can always contribute more. You can contribute personally. Reliable sources tell me there's a QR in the program and can be up on the screen. I would ask you to please consider increasing your support to this wonderful organization. I know I will be doing it tonight, and I hope you will too, and I thank you so much for this award.
Good evening. Good evening. I'm Sean Hecker, and I too want to congratulate all of tonight's honorees and participants. I feel especially fortunate to be able to call Helen and Ellen Patterson dear friends. They're not only wonderful lawyers, but they're incredible people. So please join me in congratulating them as well. And Ms. Evans, your story was inspiring and so meaningful, so I want to congratulate you. I know getting up in front of a crowd can be difficult, but you discharged that duty incredibly well, so congratulations to you. And you guys know Cravath and Ben Grunstein, they were great too. But I was asked to say a few words specifically about David Patton. And you may not know this, but this isn't the first time that I've been asked to play this role. Indeed, for me, it's all too familiar. These days, if I'm in front of a microphone and I'm not in a courtroom, the odds are strong that I'm giving some award to David Patton for brilliant advocacy, for being the best criminal defense lawyer in New York, for outstanding public service, or for God knows what else. And I'm not really sure why I'm the one who keeps being asked to bestow these awards, because the truth is I'm totally biased and not in a good way. Almost a quarter century ago, I applied, not for the first time, to be a federal public defender, and I didn't get the job because some guy named David Patton was hired. And he's annoyed the hell out of me ever since. I got hired eventually, but that just meant I had to watch firsthand a total natural in the courtroom. Former actor and all, someone who wasn't just able to argue passionately and cross-examine brilliantly, but who could be somber or stern or funny. You might have got a flavor of that tonight, depending on the circumstances. He had multiple gears. One of those things you say when you're training young lawyers, don't try this at home. He could adopt different personas for the occasion to enhance his ability to communicate with his audience, both juries and judges. And I had to witness this at a stage of my own career when I had to literally want to throw up every time I got on my feet. That too was more than a little bit annoying. And he started winning trials, a lot of trials, dozens of trials. And throughout the course of his career, in the trials where he was sitting in the first seat, he has achieved outright acquittals in more than half of his criminal trials. And there aren't many criminal defense lawyers who can claim statistics like that. That also can be a little annoying. But I have, in the end, overcome my feelings of jealousy and annoyance and come to admire and indeed love my friend David Patton. He has done more good with his extraordinary gifts than just about anybody I know. He brilliantly led the Federal Defenders of New York for more than a decade, earning the respect of those who worked with him, some of whom have aspired to this amazing bench, some of those who worked against him, some of those who have aspired to this amazing bench, and those who got to see him work, including just about every federal judge in the Southern and Eastern districts of New York. And he has continued in private practice to do the hard work, the important work of trying to improve our criminal justice system, both by training young lawyers, by mentoring young lawyers, by teaching the next generation of public defenders, of criminal defense lawyers, how to do the job better, how to make our system a little fairer. So in short, my biases notwithstanding, I think it's clear that there could be no more deserving OAD Gould Award recipient than my pal, David Patton.
I promise I'll keep this short. This award means so much to me because of where it's coming from. I am a huge, huge fan of OAD. I've been an admirer of OAD's work for a long time. It's one thing to support well-meaning causes. It's another to come out and support organizations that do what they do really, really well. OAD is just, I think Nick mentioned, described it as the crown jewel. They really are. And so thank you all for coming out. Caprice, thank you for your great leadership. It's such a wonderful organization. And so all I'm gonna do is hit you up for more money. And I thought I would do that really by sort of, I don't know, providing a little bit of a cautionary tale about what else you could do with your money. And Sean, I think, will agree with what I'm going to say. I'm going to use my dear friend Sean as an example. You could not give money to OAD. You could do other things with it. You could keep buying the same pair of eyeglasses every year, year after year for decades, thinking it will somehow change your appearance. You could spend loads of money constantly rebuying sporting goods, golf clubs, tennis, thinking it will improve your game. It will not. You could spend untold sums on publicists. So that every time you sneeze, it's in the newspaper. All right, that one's a closer call about whether or not it's worth doing. It seems to have panned out for Sean. I promise you, none of those things will make you happy. Now that I am in the private sector, now that Sean took pity on me and actually hired me at his wonderful law firm, I know what you people make. Don't spend it on those things. Give it to an extraordinary organization like OAD, truly. You're getting a lot of bang for your buck. They punch above their weight. Thank you, Caprice. Thank you to all of you at OAD who are doing what you do. And thank you for this.
Okay, so it is my great pleasure to introduce our final honoree tonight, Ellen Patterson. When she is not leading our mock court as Chief Justice, Ellen's day job is serving as the Senior Executive Vice President and General Counsel of Wells Fargo. I've known and worked with Ellen since she became the General Counsel first of TD Bank more than 12 years ago. And I can unequivocally tell you that she is one of the smartest, savviest, and most strategic lawyers I have come across. She started her career at Simpson Thacher and Bartlett, another of OAD's longtime stalwart supporters, where she was a partner for nearly 15 years. She joined Wells Fargo in March of 2020. You all may remember what that was like. It was not an easy time for any person or company. Wells Fargo, like other large financial institutions, needed to figure out almost overnight how it was going to keep the country's financial system running in a world where no one ever left their home. And in her very first weeks at the bank, she had to help navigate all of the legal risks the bank was facing, while at the same time guiding a legal department of more than 1,200 lawyers and legal professionals through the transition to remote work. Wells Fargo was also trying to rebuild its reputation and the public's trust after the sales practices scandal from several years earlier. Now, here we are 4.5 years later, the bank has made huge strides in rebuilding its internal controls and compliance systems, and as importantly, restoring its reputation with consumers and regulators. Ellen has been instrumental in that turnaround, and her efforts have led the American Banker magazine to repeatedly name her on its most powerful women to watch list. Ellen serves on Wells Fargo's operating committee, the senior-most executives of the company, and is the co-executive sponsor of Wells Fargo's Women's Connection. She also has greatly expanded Wells Fargo's pro bono activities and has more than doubled the bank's pro bono hours over the last couple of years. And if running the legal function of one of the world's largest banks weren't enough, in her free time, she serves as a member of the board of directors of the United Way of Greater Philadelphia and Southern New Jersey. And her work there includes supporting pro bono legal service to individuals trying to clear or seal their criminal records. As I mentioned, I've worked now closely with Ellen for over a decade. In addition to being a powerhouse lawyer in her own right, she's also a wonderful client. She comes to every meeting fully prepared. She wastes no time getting to the issues that really count. As an outside lawyer, it's a joy to be able to focus on what matters, and I often find myself learning as much or more from her as I hope she is learning from me. Even more importantly, she is unfailingly poised and calm no matter what the stress level is. As you can imagine, she counsels a lot of very intense and very demanding senior executives, and she does it in some of the highest stakes situations imaginable. But in all the years I've worked with her, I have never once seen her lose her cool. And in my experience, that can make all the difference in the quality of legal advice that public company senior executives receive. I've often wondered how she manages to stay so calm at the center of every maelstrom. I've never asked her, but I think I got a hint of an answer in a conversation that we had a few months ago. We were talking about politics and what would be good or bad for America, and I raised the point that something that might not be great for America could end up being good for big banks like Wells Fargo. Ellen quickly dismissed that point with a wave of the hand, saying, "But that's just work." I suspect that Ellen's family, including her 2 teenage children, also help her maintain her perspective on work and life. Now, I want to be clear, no one would ever say that Ellen is not herself an intense and demanding executive. She asks a lot of the people who work for her and expects to receive their best work. There's a reason why that robe looks so natural on her, but she does it all with humanity and humility, and that too makes an enormous difference. We are so grateful to Ellen for her willingness to be a part of tonight's event, for helping to raise support for OAD. It is my great honor to present Ellen Patterson with the OAD Counsel for Justice Award.
Thank you, Nick. That was a lovely introduction. Thank you very much to OAD for having me and for this wonderful honor. Caprice, thank you. This has been quite an experience. I have to say I'm very honored to receive this. Frankly, I'm honored just to be in this room. So I'm just a humble mergers and acquisitions lawyer turned general counsel, and the star power in this room for those who actually get up and defend and prosecute individuals and companies has been quite a remarkable event. It's really a kind of a career goal of mine to avoid courtrooms. So I'm very happy with this fake one. It's been really fun. I'm not looking to come back anytime soon in the real arena. But to Helen and David, just remarkable. Thank you for your amazing presentations and flexibility and humor. Your clients are clearly incredibly fortunate to have you on their side. So thank you for showing off that a bit. And to Ben, thank you very much for being a model of what private firms can do to continue to support pro bono. As Nick said, we take this really seriously in trying to figure out how to continue to do better and better at our support of wonderful organizations like OAD and other nonprofits in serving pro bono from the corporate side of the house. I will continue to take suggestions on how to continue to do that and advance this important work. And to my fellow fake justices, thank you very much for making us all look good up there. It was also really wonderful to hear Desheen's story, and it's just, such a wonderful example of the remarkable resilience and kindness, continued kindness of humankind. And I think it's just a wonderful example of showing how the work of OAD just makes an incredible difference for individuals, but also really for protecting the integrity of our justice system. So I thank you again for the honor, and we will, I think, get to the closing act of our decisions. Oh, and I might just keep the rope. I really think it'd be very effective in my delivering of legal advice if I can just sit, at the office, and, I think it'd really take on like a new level of seriousness. Thank you very much.
So we're almost at the end of the night, but please remain seated so we'll listen into the court's deliberations.
Okay, so we're going to begin, and we're going to ask our justices to give us just a brief view of where do they come out, and whatever you want to say on that. And we're going to start with Justice Masella.
Thank you. It was an incredibly excellent argument on both sides, I thought. Counsel for both petitioner and respondents were outstanding. It was really a very close call for me. I would have to say I was slightly more persuaded by counsel for the petitioner, Ms. Gred. I thought that her arguments resonated. Her arguments about this very complicated area of the law resonated well with me. I recognize that could be entirely colored by my own experience being on the defense side of some of these cases, which are incredibly hard to defend. And I do want to tip my hat to Mr. Patton for doing such a great job in his role as a government lawyer. But I will cast my vote for Ms. Gred.
Justice Mace.
All right. I agree with a lot of what Justice Masella said, and I think that the arguments were excellent here and highlighted the points of difficulty for both sides. I'm going to keep it interesting and cast my vote for the respondent here.
Justice Harris.
Yes, like many judges, I've already written out my opinion before oral argument, despite the excellent theatrics and persuasive arguments. I cast my vote in favor of the petitioner. For me, the rule of lenity and the due process principles that underlie that rule govern my decision today. Appellate jurists often lose sight of the fact that criminal laws are about people and that criminal charges have an enormous human toll. A prosecution can ruin lives, upend careers, and destroy families. Indeed, defining what constitutes a crime is not just an abstract intellectual exercise. It is a moral judgment about who deserves to be punished and who deserves to be jailed. And because of that, when there is doubt about the scope of a criminal statute, centuries of jurisprudence dictate that that doubt has to be resolved in favor of the charged individual. It is for that reason that I vote in favor of the petitioner. To be clear, my decision today should in no way be deemed a pass for those who lie to obtain contracts that they are otherwise not entitled to get. There are ample remedies, however, in contract law for parties to insist on specific performance or recoup whatever damages may have been incurred. The question before us today is whether an individual who did the work he was paid to do can be prosecuted and jailed by the federal government. Without more specific guidance from Congress, the answer, in my view, is no.
Justice Gaddis.
Okay, well, Justice Harris said that very well. I, too, vote for the petitioner, although I do want to commend Mr. Patton for doing a fine job trying to advocate for government overreach, as he's always doing. But I agree with Justice Harris that we have a lot of smart people here who debated this and did a good job, but the rule of lenity applies very much here, and there is no way that the government should be the one making this decision, as Mr. Patton was basically advocating. And so that this is an easy one for me. I vote for the petitioner.
Justice Everdell.
Thanks, and Justice Harris totally stole my thunder because I also gave my decision before I came here today, but you guys did an excellent job, both of you, but it is not actually reflected in my comments here, but you guys did awesome. So I am siding with the government, with the respondent on this one, and I say that knowing full well that the Supreme Court has spent the last several years issuing a virtually unbroken streak of opinions limiting the wire fraud statute. But I think at some point a case comes along that sort of causes the pendulum swing to stop, or maybe at least slow down a bit, and I think this is one of them. I don't believe that the scope of the wire fraud statute is as narrow as the petitioner would argue, or that the term property in particular is that narrow. Simonelli holds that the wire fraud statute protects only traditional common law property interests, but in my view, that property interest encompasses not only the right to decide what you spend, but how you spend it. Here, the Penn DOT didn't want to spend its money on just any old paint job. It wanted to spend its money on a paint job that was done in a specific way that benefited DBEs. And it made DBE participation an explicit condition of receiving the contracts. So when the petitioners lied to the DOT about that explicit condition, which was, to use another phrase, an essential element of the bargain, they committed wire fraud.
Justice Diskin.
Thank you. I also would vote for the government here, although David and Helen both did a wonderful job with a challenging bench. In my view, the scheme as charged fits fairly comfortably within the confines of 1343, that is, false and fraudulent statements to obtain money or property, in this case, a $70 million contract. I also agree with Justice Everdell. I think this is likely to be the end of a certain chain of cases. I think it's different from Kelly in that the property was not incidental to the scheme, and I also think it's different from Simonelli in the manner in which it was charged. And so I would vote for the respondent.
Thank you, Madam Chief Justice. I'd also like to extend my congratulations to the presenters. I too wrote a fairly long opinion, so I'll only read the initial portion of it. I too find that the respondent, the government, have won out in this situation. The premise of the petitioner's position requesting that we overturn the Third Circuit's decision with respect to the company Alpha's conviction is that there was neither an economic harm nor intent to cause economic harm. Whereas in this case, the object of the scheme is precisely to obtain payment on a contract that would not have otherwise been awarded, but for continued misrepresentations regarding one of the fundamental terms of the contract, I find the elements of the wire fraud statute have been satisfied. Absent the continued false certifications by Alpha, the contract would have either not been awarded altogether or would have been voided for failure to comply. The false DBE certifications, therefore, were a means to an end, that end being payment under the contract. This resulted in actual pecuniary loss in the forms of millions of dollars in payment to Alpha and its subcontractors, including the 2.25% markup that would otherwise not have existed but for the misrepresentations regarding the DBE. Because on the record before us, there's clear evidence that Alpha intended the economic loss suffered here. I see no reason for the court to decide on these facts whether non-economic property interests existed, and if so, whether those interests needed to be intentionally harmed. The rest of my opinion will be available online.
Well, Justice Cassidy, nearly as exciting as the score of the Yankee game. We're at 4-3.
Well, I must disagree with Justice Cruz Melendez and agree with my colleagues who voted for petitioners. And I agree with Ms. Gred's argument that the standard presented by the government in this case is an unworkable standard. As demonstrated by the varying outcomes in the cases discussed by the parties, one cannot know in advance where the line between mere deceit and criminal wire fraud lies until an appellate court weighs in. And that is not how criminal law is supposed to work. So I agree with my colleagues who have already said that deprivation of money or property is not found when the victim does not suffer an economic harm and there was no intent to cause one.
I get to decide. I'm so qualified to do this. I won't keep you in suspense. I'm in favor of the petitioner as well. I think Justice Cassidy summarized my views very similarly. I don't think that in the absence of economic harm, I do not feel that the government was deprived the benefit of the bargain. I found the materiality argument just too unclear and too requiring the parsing of terms in a criminal situation. And so we are 5-4 in favor of the petitioner.
I respectfully dissent.
That brings our program to an end. Thank you so much for joining us, and I hope we will see you next year on October 6th, 2025. Have a good night.
Yeah. Do you want us to come in? Or? Okay, stand up.